Hey, let's get started. Thanks for being with us today. This is the Energy Law Lecture Series, and it's the last one for the spring semester, last one for the year. So appreciate you guys making time in your schedule to join us. It's going to be well worth your time and effort to be with us today. And I'll introduce our guest speaker for today here in a minute. Those of you who have been with us during the semester know that we had, in addition to today, we had Representative Ken King earlier in the semester. We had Public Utility Commissioner Courtney Yaltman, and then we're wrapping up with Micheal Dobbs today. And it's been a great semester of speakers, and I hope you guys have been able to attend and benefit from all of those as well. Welcome to our Zoom audience. Thanks for those of you on Zoom who are joining us. Those of you who are going to be looking for CLE credit for this lecture today, just stay tuned. At the end of the lecture, we'll put the QR code up on the screen so you can use your phone to register for that 1 hour of CLE credit with the State Bar of Texas. Okay. I also want to point out that today's a special lecture, even beyond our other lectures, in the sense that it is referred to as the Terry Grantham Memorial Lecture. Terry Grantham was a tech law alum who was very well thought of, very successful lawyer here in Lubbock, served as an adjunct professor, was on the Law School Foundation, and so forth. He received his law degree from the law school and was admitted in the Texas Bar in 1982. He was a partner with a law firm here in Lubbock, Craig Terrell, Hale, and Grantham. He was the Grantham in that name, where he specialized in real estate and oil and gas law. And like I said, he was also an adjunct professor at the school for a period of time. This memorial lecture was endowed through the Texas Bar Foundation in 2014 by his family and friends, and the award is given. There's an award in addition to the lecture that's received by the recipient who lived and practiced law like Terry did in Lubbock, passed away back in December of 2012. So Terry Grantham is a special alum, and this lecture was endowed to remember him. And this lecture, one lecture a year, is always referenced as the Terry Lee Grantham Memorial Lecture, and it's this one with Micheal Dobbs today. So I just wanted to take a minute to point that out and let you know that it was special in that sense as well. Those of you who are looking for maybe one more energy law program event to attend before the semester's out, this is the end of the lecture series, but we'll have one more nuts and bolts event if you're interested a week from Friday. So Friday the 24th. Those meetings are at noon in room 202, and those are typically designed to bring in speakers who kind of pull back the curtain and show you different kinds of opportunities that exist in the real world when it comes to practicing in the energy law space. That's going to be with our guest speaker, Kyle Reynolds. Kyle is has been serving as and is now on his way out as the current president of the American Association of Professional Landmen. Very important organization, important position, and he's been very busy all this year traveling and speaking to the different chapters around the country, and he made time to come see us a week from Friday. So those of you especially who are interested in possibly doing land work, this would be a great one to attend because Kyle's a great guy to get to know, so might mark your calendars for that one as well. Okay, well, let's talk about today. So our guest speaker today is Micheal Dobbs. He's Senior Vice President, Secretary, and General Counsel of the Texas Pacific Land Corporation. He brings more than 2 decades of experience in property and mineral rights, water rights, easements, leasehold negotiations. Prior to joining Texas Pacific back in 2020, he was a partner at the Houston office of Kelly, Dry, and Warren. And we've been talking before the lecture today, and he was telling me about all of his experience in addition to working at Kelly Dry. And boy, Texas Pacific got the right guy to be running the show because he's got the right experience and has just been building on that experience. You're going to find out a really interesting story about this company and even more interesting about what they're doing in present day. So look forward to that, and help me welcome Micheal Dobbs.
Thank you very much. And that was a wonderful introduction. So I'll skip the part about who I am, other than I will say that I started working for TPL in probably about 2017 when my firm merged with Kelly Dry, and Kelly Dry had been representing the trust, Texas Pacific Land Trust, for over 100 years, and a lot of the historical documents and stuff that we've been able to gather, a lot of those have actually come from their files. So just a little bit about who the company is today, and hopefully I'll get to circle back to this, but today, Texas Pacific Land Corporation is the reorganization of the Texas Pacific Land Trust, one of the largest landowners in the state of Texas, with about 880,000 acres that stretch from El Paso past Midland. We've got kind of three lines of business. We've got a kind of a surface business, oil and gas royalty business, and a water business. Market cap today, at least this morning, was about $28.5 billion. That's the value of all the stock out on the stock exchange. We were the S&P 500, which is indexed the 500 largest capitalized companies in, I think, the world. Last year, our revenues were just under $800 million. We had an EBITDA margin of 86%. So we run a very capital light, high margin business. No debt. Have mineral royalties covering 28,000 acres on a net basis, and on a 1/8 basis, 224,000. We're headquartered in Dallas and have an office in Midland as well. Currently have about 120-ish employees compared to 2016 when there were 9. So this is kind of hopefully take you from the beginning all the way back to how things have really transitioned over the last 10 years. But it all starts back in the 1800s when railroads were the thing. They were the tech of the time. And both the federal government, state governments would grant some of their public lands to the railroads as an incentive to get the railroads to build tracks. Texas was unique amongst a lot of the states, or all of the states in particular, because it got to keep title to its public lands when it joined the Union. Originally in 1844, Texas, the Congress tried to annex Texas and were unsuccessful in voting that through, mainly because Texas had $13 million in debt, a lot of money at the time, and issues with slavery, which won't get into here. But the following year in 1845, Texas was admitted to the Union, getting to keep its 250 or so thousand acres of public land, maybe more, and it's $13 million in debt. And I think that's probably a pivotal moment in Texas history that most people don't think about, because if Texas looked like the other states to the west, with the federal government owning more than half of it, I think it would be a very different state than it is today. But Texas at the time was asset rich and cash poor, which is a thing that's going to kind of permeate some of this. But the Texas and Pacific Railway was a combination of several railroad companies, finally got a charter in 1871 to build a railroad from Marshall, Texas in the east to San Diego, California. It was chartered by both Texas and the United States, New Mexico, and the other states along its route. By 1877, it had built 404 miles from Texarkana and Marshall to Fort Worth. And Jay Gould, who was the, I guess, railroad robber baron of robber barons at the time, took control, and between 1880 and 1881 built an additional 523 miles from Fort Worth to Sierra Blanco, southeast of El Paso. The way the land grants worked, for part of it, railroads were given 10 sections for every mile, or 10 sections either side of the track for every mile, and that was extended in the Pecos area, which you see in red there, to 20 sections for every mile of track. That left about 7 million acres to be conveyed over to the railroad if it built the track that it had promised to build in the time specified by the grant. The way that worked is the railroad get the odd sections, and the even sections would go to the state's permanent school fund. The railroads, and later TPL, the trust, were responsible for surveying those tracks. So fast forward, like all booms, they come to a bust. and the Texas Pacific Railroad was no exception. There were floods in the east and droughts in the west, and traffic on the, quickly built line to the west into Pecos was light, and the railroad finally went into receivership in 1885. The way the railroad had funded building the railroad was to issue mortgage bonds, and those bonds were secured by the land grants that were provided. And as part of the, we'll get back to this, as part of the foreclosure, we call it bankruptcy in our, when we usually talk about the company, but this really predated the current bankruptcy statutes. But about 3.5 million acres were handed to the receiver to be put into a trust for the bondholders. And as you can see on here, it's a pretty good depiction of the extent of the 3.5 million acres from El Paso, well past Midland, all the way up past Abilene and the like. And the railroad received title to every other section in that hatched area. There's a picture of a bond we'll get here in a minute. I mean, a TPL trust certificate, and Mr. Gould. Let's see. So the decision was made as to secure the bondholders was to create a trust. Corporations at the time were, I don't want to say disfavored. There were a lot of limitations on corporations at the time. They, in a lot of places, including Texas, couldn't own property outside their operating area. There were lots of restrictions on par value, voting rights, mergers, things like that, that today's corporate laws kind of give flexibility to. One of the ways around that was business trust, which were really popular until about the 1920s when you got to the Sherman Act and kind of the trust busting years. But the way TPL was structured was through a 1888 declaration of trust that conveyed both legal ownership, equitable and legal ownership of the assets to the trustees. They had the right to hire lawyers, accountants, surveyors, agents, borrow money, buy property. They were originally selected in the initial grant, and then if a trustee were to die, resign, or be removed, they would be elected by a majority of the certificate holders outstanding. Certificate holders were those parties holding the railroad bonds at the time. They were exchanged for trust certificates on 10 certificates for every $1,000 bond, plus a second mortgage on the remaining railroad property. The trustees were paid $2,000 a year, and the chairman was to be paid $3,000 a year. That payment structure actually extended all the way to 2019, when the trustees finally decided when they needed to recruit a third that maybe we could adjust this for inflation. They paid dividends, but the big thing that the trust was meant to do was to repurchase shares, which were listed on the New York Stock Exchange in 1888, and retire them upon purchase as a way to return money to the bondholders. Let's see here. So what happened was the 3.5 million acres were put into the trust, and they began working to sell land. They would also, long lot of revenue was generated. I say a lot of the revenue generated by the trust was for grazing leases. And it wasn't until about 1915 when the first oil and gas lease was executed by the trustees. Oil was really just becoming, being discovered and developed in West Texas in the late 19-teens into 1920. But for the first few years, things were a little tough. I think for a few years, they didn't even generate enough income to pay the trustees their salary. But once oil was discovered, things changed, and things changed dramatically. Let's see. So the first, what we still say is first oil well in the Permian Basin, but the first well on TPL Trust property was drilled in July of 1920. It was the W.H. Abrams Well Number 1 in Stevens County, and it initially produced over 20,000 barrels a day. Mr. Abrams was the land commissioner for the Texas Pacific Railway, and he's also the first general agent of Texas Pacific Land Trust. And from that point on, revenue shifted to mainly oil and gas. At some point exceeded 96% of the revenue the trust collected. And likewise, the certificates which had been listed on the New York Stock Exchange since 1888 went up in value considerably. By 1929, this certificate price had risen to, I'm sorry, I gotta switch my gears here. Income by 1929 for the trust had risen to $567,000, reaching a high of just under $8 million in 1954, largely from oil and gas income. By that time, in 1927, the trust had already repurchased 75% of its outstanding certificates, and the stock price at that time had reached $3,600, which was the highest price of any stock on the New York Stock Exchange at the time, resulting in the trustees having to issue sub-share certificates, which were 100-to-1 to the original trust certificates, as a way to have more liquidity and more shares outstanding. As oil and gas revenue continued to grow, the share price reached what was an all-time high at the time, which was $19,500 per certificate, or $195 per sub-certificate in 1952. And you can see on the map, it kind of a good explanation of kind of some of the land and mineral holdings at the time. Well, that created another problem. Now the trust has way too much money and nothing to spend it on. It was spending all of its money before the 1950s on repurchasing shares. In the 1920s, it started its, or 1936, started its first dividend, but by the 1950s, the price was well beyond what the trustees thought that was appropriate to spend on buybacks. All revenue was distributed back through dividends, which created the problem of taxes. So by the time 1950, the trust was paying about 70% in taxes. That was before the tax on certificate holders when they received a dividend. This was largely due to the Korean War excise profits tax and the fact that the trustee or the trust had very few expenses and was mainly paid trustees' salaries, some office, and then they hired land agents whose main form of income was overrides on oil and gas leases. And so a lot of the certificate holders kind of pushed the trustees to do something about it. And what they wanted them to do is drill their own oil wells. Well, the trustees didn't believe that the Declaration of Trust gave them that power. It gave them broad, expansive powers, but they felt that the purpose was to be a liquidating trust, sell the assets, repurchase shares, and not be an operating business. Today, I might kind of question that because they could sell, lease, grant, improve, encumber, or otherwise dispose of the assets. And how would you dispose of oil? Just like if you're pumping water out of the ground, you pump it out of the ground and sell it. But they felt very strongly that they couldn't form an oil company. But one of the things the trust declaration did allow them to do was to form a corporation. They said this trust declaration was put together at a time when corporations were, whether it's limited, but over time, flexibility in the law and the way corporations manage themselves, it changed substantially. And they felt that under the Declaration of Trust, although they couldn't drill a well, they could create an oil company to do so. So they went about the process of figuring out how to create an oil company. Looking through the old files, it's kind of replete with history of every large firm in Texas and in the United States at that time. All of the kind of original treatise writers and folks that underpin oil and gas were involved at the time. It's very interesting to go back and look through some of that stuff, and especially as a lot of it's privileged, but you've got the trustees, and you've got New York lawyers, and you got Texas lawyers, and the Texas lawyers trying to describe to the New York lawyers what a royalty is and MPRI is and what taxes are involved. And it shows you that, you know, this stuff was still, some of it was still in its infancy. And so some of the royalty provisions and stuff were kind of outside the norm. They even have a lot of stuff where they had to try to educate the IRS on what they were trying to do. But the options were a few. They could create a company and lease the minerals to the company, like any other kind of oil and gas lease, maybe on a longer term. They could try to convert the trust into a corporation that they felt required a 2/3 votes to certificate holders, which is logistically hard to do, if not hard to do, because you got to get 2/3 of people to agree on something, which is difficult at times. Or they could create a corporation, convey the minerals to it, and hold on to the surface and continue to liquidate the surface like the trust had been doing over the time. And so they decided to go forward with conveying the minerals, spinning them off into a corporation. And so in 1954, the trustees filed suit in Dallas County District Court to seek an interpretation of the 1918 Declaration of Trust, saying that they could form a corporation to convey the minerals, and had an order issued in 1954 confirming that they had the power and the authority to do that. And so the trustees created TXL Oil Company and conveyed 1.9 million acres of minerals, fee minerals, to the oil company, reserving to the trust non-participating royalty interest. At the time, and maybe even still today, the IRS would not let the trustees reserve a royalty on things that were not under lease. It would be considered similar to either a lease or an override, and would not be given tax-free treatment. So the result was the trustees reserved a non-participating royalty interest over what was under lease. That royalty interest was a 1/128th on anything under lease at the time, and a 1/16th on anything that was under lease but not producing. Well, you can see the extent of the minerals they conveyed. I would say about half were what you would call core Permian minerals, and about 950,000, and the others out west and near El Paso, down south, Van Horn and stuff like that, at least weren't under lease and haven't really developed any oil and gas production. So with that, you had about 386,000, almost 387,000 acres that the trust reserved a 1/16th non-participating royalty interest, and 85,000 acres with a 1/128th. Most of that production was in the Midland Basin. So if you were to look at the trust legacy royalty interest, Midland, at least legacy, is the 1/28th, much smaller fraction of a well, and then the Delaware is a much higher 1/16th. At the time, that standard royalty in an oil and gas lease was an 1/8. So a 1/16th was essentially a half interest. The way that was spun out is the oil company was created, and then trust certificate holders each received equal number of shares in TXL Oil Corporation. The conveyance from 1954 is probably one of the, I would say, very thoughtful document in which a lot of really smart people spent a really long time structuring and putting together, and was very forward thinking in a lot of things. It provided a proceeds royalty, including provisions that no cost should be charged back to the trust A lot of the common law duties to market and to act in the executive role were spelled out. It even had a floating royalty that if the royalty interest did not reach $300,000, that royalty interest would step up for a term of 10 years. The royalty was to be included in all new leases. TXL was to pay the ad valorem taxes on the royalty interest that was reserved. Even had an extensive definition of oil, gas, and other minerals that included all gases, coal, lignite, all your minerals, uranium, ferrous and non-ferrous metals, all oils, or oil and petroleum, oil and gas, any of the other hydrocarbons. Did not include what you would consider surface minerals like gravel, surface lignite, marble, limestone, gypsum, and water, except water was included in the definition to the extent it was necessary to extract the minerals. For a while, TXL operated as an independent oil company, almost as a sister of the trust. The trustees were on the board and some of the executives. But like in early years, it was asset rich and cash poor. By 1962, it had been acquired by Texaco, and later Texaco in 2002 was acquired by Chevron, giving Chevron about 950,000 acres of kind of core minerals, about half of which is burdened by TPL's NPRI. From that point forward, the trust kind of operated as it had in the past. It collected oil and gas revenue from the royalty interest that it reserved. It paid dividends and repurchased shares. That repurchasing shares over time resulted in there not being enough shares on the exchange to meet the exchange trading rules or to ensure that there was enough liquidity in the stock. So a number of stock splits were issued. In 1917, there was a 2-for-1 stock split. In 1980, there was a 3-for-1 stock split. 2007, there was a 5-for-1 stock split. And then recently in 2023, there was a 3-to-1 stock split. And then in 24, another 3-to-1 stock split, which resulted in a 27,000-to-1 ratio between the original trust certificates. But taking us all the way up to near the present, so 2016, TPL really still operated as a liquidating trust almost from the 1950s. It had 9 employees, all were in Dallas. The trustees personally signed every contract. It got shepherded around the country. And getting an easement or a lease or anything usually took 6 to 9 months just because you had to send it all around the country to get signatures. They still use typewriters, carbon paper, hand-drawn maps. All files were hard copy with card catalog system. Leases and sales were just done. If someone showed up and wanted one, they were given. No one was necessarily out in the field looking to see if anybody was trespassing, put things in the wrong place. It really did act like a mailbox. And so in 2016, our CEO was named the general agent and knew that TPL could be a lot more given its land holding. And so most of you all know about the Permian Basin, but the Permian Basin stretches from most of West Texas down to the south, up into New Mexico. You have the Delaware Basin, which is on the left, and the Midland Basin, which is on the right. It covers about 28,000 square miles, 17 million acres, about 10 different kind of current pay shale benches. And at that time, kind of people called it the shale revolution, but hydraulic fracturing and horizontal drilling had really resulted in an uptick of development. And our CEO felt that given TPL's position, it could do a lot more than it had, and so went about the process of starting to modernize things. So took the position of TPL being a landowner and a royalty owner, especially with a footprint as large as it is and owning every other section, should be able to capitalize on the full development of an oil and gas well. So before wells even drilled, and when a permit's filed, operators are going to need a lease for a pad site, subsurface lease for well bores, pipeline easements, utility easements. They're going to need caliche for well pads, all those type of things. And although some of those things can be done under lease rights, the way the Permian is situated and the fact that today horizontal drilling goes 2-3 miles, several sections, that none of that stuff can usually be done under one lease. Or if it can, that lease is isolated. And so you're going to have to cross TPO to get there somewhere. So really focused on expanding what we call active management, sent people out into the field, identified trespassers. It took 2 years to just paper up all the trespassers. There were frac tanks, holding ponds, houses, everything you can imagine built on TPL that no one had got an easement, lease, or otherwise. And for a while, we weren't the favorite of the industry because we were knocking on everybody's door and telling them how much money they needed to pay. And here's our form, sign it or move your stuff. The other thing was water. So today's wells can use, with simul-fracs and trimul-fracs and the other names that they're using to frac multiple wells at once, can use 300,000, 400,000, 500,000 barrels of water a day. And as the surface owner owns the water rights. And TPL had a huge amount of water that it had traditionally just let folks come on, take, and pay a small royalty, and felt that if we built a water business, we could do a lot more with it. Hired a team from EOG and started a water company. Started out from a hotel room at the DoubleTree in Midland. Went about buying hoses, securing ponds, getting right away, and developing a system that today we sell about 1 million barrels of water a day. And it stretches, I think we can pump sometimes upwards up to 100 miles into New Mexico, delivering brackish or even sometimes treated produced water for fracturing wells. The next thing was all Permian wells have a heavy water cut, heavier in the Delaware than the Midland. On average, it's 4-to-1 of water to oil. It can go up to 6, 8, 10-to-1 in certain places. And all that water has to go somewhere. Typically what's done is it's injected back in the ground. That pore space is also owned by the surface owner. So decided strategically not to drill own disposal wells, but to lease the subsurface for saltwater disposal, and also provide access across our footprint as far as easements and the like, and somewhat forward thinking, and limited all our disposal wells to disposal only, with the idea that one day we'd be able to treat produced water and resell it. Also reserved rights to offtake from midstream systems, take that water, sell it to be treated and reused in oil and gas fracking, and then, if necessary, put it back on the system at no cost, the TPL. And so began what we call our produced water business, which we charge a fee. We call it a produced water royalty fee, either to dispose of produced water or cross TPL's property with produced water. A lot of this also, we're able to use our surface position to drive development of our oil and gas royalty interest, and end up getting revenue streams that start from before the well is drilled all the way through when the well is completed. Those changes really dramatically change TPL's revenue and its business model. In 2016, revenues were about $66 million. $8 million of that was from water sales. And they had 9 employees. Our Stock price split adjusted was $35 and the market capitalization was 2.5 billion. Today, over 100 employees. Annual revenues, like I said earlier, were 798 million, with 370 of that coming from the water business. The stock price has risen significantly to, I think this morning, over $400 a share, and market capitalization of $28 billion. All of that was in 10 years. I joined TPL in 2020 in the latter half as part of kind of the effort to modernize the company and bring it forward. But you can see on the next slide kind of the revenue streams. Still a large portion of the revenues, just straight up oil and gas revenue. We have spent the last couple of years deploying a lot of capital, probably $1.5 billion on acquiring royalty interest, partially to kind of diversify our position. It's very Delaware focused. We bought a lot of Midland Basin minerals. As I mentioned, the surface, what we call surface damages, or we call it SLIM, revenue makes up about 11%, water sales 21%, and our produced water royalties 16%. But our produced water royalties and our oil and gas royalties are essentially a 100% margin business, and provide what our shareholders have come to like about TPL, which is a high margin business. Still have no debt today. Let's see. And here's kind of a footprint of both surface and mineral holdings. You can see the combination of green is both surface and minerals. The blue is purely surface, and the brown or maroon is just a pure royalty interest. We were some of the first to go out and acquire pore space or surface outside the basin over in Andrews County as a way to handle the significant amounts of produced water that are building up in the Delaware Basin and causing issues, and have leased that out to midstream companies to take produced water from Loving County and send it all the way over to Andrews County as well. Let's see how much time I got there. So we're through some of this, but then that came to the trust had operated under this trust structure that had some limitations. Definitely, it really limited what institutional investors could buy our stock. We had a significant portion of what we call retail investors, individuals. TPL had been a stock that sat in people's family for generations. They were always told, never sell this stock because one day you'll be the last one. Even Warren Buffett talks about TPL that it was the first or second stock he ever bought as a teenager, because he thought if he lived to 100, he would own it all. And we had a lot of shareholders who felt the same way, that they were given the stock by their father, their grandfather, and told never to sell it. And but by this time, the business had grown to the point where really was even more missed opportunity being restricted under the trust structure. So in 2020, or 2021, finally put it into place, but went through a corporate reorganization. And so decided to follow what was already done in the past. So we already had an opinion from a Dallas court that said the trust could create a corporation, convey its assets to it, distribute the shares, and so that's what was done. A long process to unfold, but the nuts and bolts of it were the trustees created a corporation, Texas Pacific Land Corporation. They conveyed all the assets, liabilities of the trust into an LLC, which was then conveyed to the corporation, and all of the shares of the corporation were conveyed and returned to the trustees, who then distributed them out on a one-to-one basis to all the certificate holders, resulting in Texas Pacific Land Corporation being the surviving entity, the trust having no more assets, essentially dissolved or disappeared, and we moved forward With that, we were incorporated in Delaware as a Delaware corporation, have board of directors, currently 8 members, had been 10, made up of professional business executives, accountants, lawyers, CEOs of other companies, and kind of professional directors that provide oversight. Greatly expanded our accounting department, legal department. We've got 6 lawyers now. Still use a lot of law firms, but do a lot of our own work in-house, and have really kind of taken what was a sleepy kind of mailbox and turned it into, you know, a wonderful business, and the market has rewarded us pretty well. But kind of to summarize, it dates back all the way to 1888. I miss saying, but TPL is the 7th longest listed stock on the New York Stock Exchange. The ones ahead are some of the utilities from before, like Consolidated Edison and a couple of the railroads, but been on the New York Stock Exchange for a long time. Actually had the pleasure to go and ring the bell a couple of years ago, and they pulled out their archives and had the original handwritten listing of the shares in 1888, along with the listing of the sub-certificates in 1927. I'll get to that. So there's a lot more to that history. I could probably spend 4 or 5 hours. Each one of these has its own twists and turns and stuff. But I thought, like, one of the neat kind of factoids out there that spanned like 40 years of litigation, if I got to it, I would, and I will. So by the 1936, the trust started declaring dividends, and it became apparent that one of the certificates was receiving dividends that weren't being cashed. Originally, they were going to what was a brokerage in New York, Blake Brothers and Company, and realized that that brokerage had dissolved. The trustees started putting that money into a bank account. By 1950, when the price of trust certificates had grown so much, the brokerage that had succeeded or bought the assets of Blake Brothers and Company decided that they would try to get reissued to them. So they filed suit in New York District Court and lost, because as most folks know, at the time and still today, brokerages usually buy stuff for clients, not in their own name. The trust certificate was never listed on the assets of the brokerage. The only records had were the trust that it had issued 4 or 5 certificates to that brokerage, and all but certificate 390 had been exchanged for sub-share certificates. They lost at the New York Supreme Court. Not to be outdone, they came to Texas and filed a lawsuit in Texas, seeking to have the trust certificate, a new trust certificate issued to the brokerage. They lost to the trial court, same reason. Lost at the Court of Appeals in Texarkana. Not to be outdone, they lobbied the legislature to change the rules, to change the standard of proof, specifically for a brokerage succeeding to a brokerage that had a certificate in a business trust in Texas, on what amount of proof was required to have that certificate reissued to the brokerage. Filed suit again, lost at the trial court, partially on res judicata, and partially the court considered the statute to be unconstitutionally retroactive and legislative interference in the judicial process, since the court had already decided it. Court of Appeals, same thing. By that time, I think between Texaco stock, TPL certificates, and dividends, it was $3.5 million. I know by the 1980s, about $170,000 in dividends were being paid to the certificate. State of Texas decided that it was lost and should be turned over to the state as lost property, and filed suit against the trustees. That sat idle for a long time, but did stir up a lot of newspaper articles, and people, like this article there where amateur sleuth is searching through basements and old dressers and safety deposit box looking for this lost certificate. And the gentleman in San Francisco was reading the paper and saw a public interest article about certificate 390. And he happened to be the one that had cataloged the files of the Wells Fargo. Wells Fargo in San Francisco had bought the old Wells Fargo bank files from American Express and had 4.5 tons of paper shipped to San Francisco. And he was the fortunate or unfortunate one to have to catalog all the historical documents. And he remembered seeing the certificate in the file. So Wells Fargo digs out the other papers that are with it, and puts it into the registry of the court. So that leads to more litigation between the heirs, which I'll get to in a minute, and some of the continued brokers. And it turns out that the certificate was payment in part for a debt to a Colonel DeLamar of New York, who was a rich mining and industrialist at the time. His mansion there on Long Island, Primrose, was one of the last to ever be torn down, I think in the 60s. His New York residence, I think, is the Polish embassy. And the papers showed that the bank was working for him. They were trying to collect a debt. They had received the trust certificate and some railroad mortgages as partial payment, essentially set with the bank all this time. So at a jury trial, jury found that the certificate was in fact that of Captain Lamar, and he had one surviving heir. I don't remember if it was a daughter or granddaughter who was a socialite in Palm Beach, had no heirs, and didn't know anymore, wasn't any richer to have received that certificate than before. But it did span about 40 years of litigation and included lots of common law legal things. Interesting, the courts would say that this is a trust certificate, it's not a stock certificate, so all the statutes of stock certificates don't apply, but we'll use some of the same logic. But it ultimately wrapped up not being some poor person that hit a windfall. Although I do have stories about shareholders who have called that remembered 20, 30 years ago, I had trust certificates. Now I can't find them. I had one that he was so excited because his shares today would be worth over $1 million. This was 3 years ago. Turns out that he went to grad school in Arizona, had moved, didn't change his address. His shares were turned over to the Arizona Secretary of State, who was holding like $270 for him. Although he was not as disappointed as I had thought once we ran it down, because if $1 million would have changed his life, I think he would have felt a lot different on the phone. But it does happen. But long history, like I said, I could probably spend 4 hours going through all the twists and turns, but at a high level, that's TPL. Good lawyer, I wouldn't fail to include a disclaimer. But it's a long history. I think if y'all do mineral work, title work, you'll see the TMP Railroad survey stretches all across the Permian. A lot of that was surveyed by the railroad, and then the trust had to do some follow-up surveys. And there's probably even a course on surveying and all the twists and turns of the TMP survey. So, but I'll leave you with that.
Thanks, Michael. Thanks for being with us. If you guys are interested in more of the story or want to have an opportunity to ask questions of Michael, you obviously can come down now, but you can also join us for my Oil and Gas Law 2 course at 2 o'clock in room 106. Thanks for being with us today.